Leader, taking the place of Representative Martinez. Thank you for being here, Representative Woodard. Appreciate that. We are going to work some bills, so you will get to do a committee vote. Yep. Okay, that's going to be after we have 3 bill hearings today. And we're just going to go ahead and jump into Senate Bill 186. And I will ask Jason Thompson, our advisor, to give us a brief on Senate Bill 186.
Okay, thank you, Madam Chair. As you mentioned, Jason Thompson, Revisor's Office. So Senate Bill 186 comes to you as introduced in the Committee on Judiciary in the Senate and passed the Senate 40-0. It is a bill concerning probable cause affidavits and requiring those to be made available to law enforcement agencies prior to the execution of a warrant or summons. The statute that's amended is KSA 22-2302. That's the statute about issuance of arrest warrants. You'll note there in current law that you can see some strike. Actually, I'll note the strike in lines 20 through 25 is a provision that expired, essentially. It was for warrants that happened prior to July 1st of 2014 when we last amended this statute. So that's kind of a technical cleanup while we're in there. There won't be any more of those. So beginning then in line 26, you'll see the new language in the provision that remains. Affidavits or sworn testimony in support of the probable cause requirement are not open to the public until the warrant or summons has been issued, or has been executed. That's the current law. So the bill provides there with the changes on lines 28 and 29 that those affidavits and sworn testimony shall be made available to law enforcement agencies prior to execution of the warrant or summons. So that's that little language that's inserted there on lines 28 and 29 in an otherwise very long statute that has a lot of current law that's unchanged. It would take effect on July 1st if adopted, and I'll stand for questions.
Okay, thank you. Committee, what questions do you have for our revisor? Any? Okay, thank you, Jason. Oh, I'm so sorry. Representative Lewis.
Thank you, Madam Chair. So currently, is it the case that law enforcement does not get a copy of the, let's see. Yeah, right. So currently, how does it work? And what are we changing exactly?
Yeah, Madam Chair, if I might, I think I'll let the conferees kind of get into that. The statute just talks about how the affidavits or sworn testimony in support of the warrant are not, or the summons, are not open to the public until they're executed. And there's apparently an issue with how that is being applied, and law enforcement is asking you to insert a provision that says very clearly that they are to be made available to law enforcement prior to execution, and then the general public has to wait until after it's executed. So I don't know the specifics kind of beyond that.
Okay, so it may be that we're just conforming the law to practice.
It might be. And unfortunately, I didn't get to watch the Senate hearing on this one, so I don't have the testimony in front of me. So
I'll wait and ask questions later.
Okay, any other questions? Okay, thank you, Jason. Okay, we will go ahead and call up our, well, I guess he's on WebEx. And Cole, welcome back, by the way. Glad to see you. We will, your replacement did a great job, by the way, but yeah, we'll go ahead and have the testimony, the proponent testimony of Sheriff Jeff Easter from the Kansas Sheriff's Association, Chiefs of Police, and Peace Officers. And Sheriff Easter, can you hear us?
I can, yes, ma'am.
Okay, great. And we can now see you too. So please continue with your testimony.
All right. Chairwoman Humphreys and committee members, appreciate the opportunity to talk with you today. I'm representing all 3 associations. To go back to Representative Lewis's question, so before OJ made the decision to go to the statewide Odyssey system, here locally in Sedgwick County and in most of the counties, they had their own systems that the courts worked through along with law enforcement, DAs, and county attorneys. We were not asked for any input into Odyssey whatsoever, and this has been about a 4-year process. And so Odyssey was rolled out by OJA to a lot of the smaller jurisdictions. When they got to the larger jurisdictions, it took us 3 years to get information that we used to have access to back to having access. And that's including DA's offices. They file sync cases. They didn't even have access to their own sync cases. And so one issue that is still lingering out there is that when a police department or sheriff's office files an affidavit to charge somebody with a crime, that goes through the DA's office to the judge to sign, and then it needs to be transferred over to the sheriff's office by statute so we can take all that information, enter it in NCIC, confirm the warrant, and then put that information out. Because of the way that OJA has this configured, we are the same as the general public, which means we don't get access to that information. And in my case, I had to hire somebody that now does nothing but on these warrants is go back to the DA's office, trace everything down so that we can do what we're required to do by state statute. We are simply asking that OJA opens that portal to law enforcement so that we can electronically get the affidavit to do what we're required to do by statute.
Okay, and are you ready for questions?
Yes, I can stand for any questions at this point.
Okay, that would be great. Okay, committee, what questions do you have for Sheriff Easter? Representative Carmichael.
Thank you, Madam Chair. Nice to see you, Sheriff. This seems
Good
to
to
be
see
a
you.
good idea, but the devil is always in the details. So let me ask you about the details. What you contemplate is an electronic access portal so that you can get the information to enter it on NCIC or whatever its equivalent is. Is that the thrust of this?
That's correct. We need the information to enter into NCIC, which is by state statute that sheriffs have to do.
But when I look at the language that has been employed here, it simply says the affidavits or sworn testimony shall be made available to law enforcement agencies, plural. It doesn't seem to restrict it to the law enforcement agency that's executing the warrant. It seems to say that if in your jurisdiction, and maybe I'm reading it wrong, but if in your jurisdiction that you've issued a warrant, you need this information for legitimate purposes, it seems like it's not restricted to your agency, that the sheriff in Lane County, who's a fine man, and I know he wouldn't do this, but it looks to me like any law enforcement agency could access that information. And sadly, sometimes law enforcement officers are the subject of warrants. Can you help me with that? I may be missing something here.
Yeah, so it does need to be allowed for every agency because right now OJA has made the decision not to open that up and keep us with the general public. Now, it's my understanding that when they purchased the software from Tyler, who owns Odyssey, they didn't purchase the entire software. They only purchased X amount of the software. That's why we've ran into so many problems of the different issues that we used to have access to that we don't any longer because they didn't purchase the software to allow that to happen. But we've worked workarounds on that. To answer your specific question, right now, if it's something like that, well, then you can request, the agency can request that to be sealed. And so if the part you're talking about, if it's a warrant on a law enforcement officer, that can be sealed. However, a warrant is a warrant in our eyes. And in every other sheriff's office across the state, we have to have access to this information real time instead of sending somebody back to figure out what we need to know about from the DA's office who filed the warrant. And everything else is electronic. That's why we don't understand why we're not being allowed access to this. And we've tried several times with OJA over the past 3 years, and this is still a sticking point.
Yeah, and I don't know anything, Madam Chair, about what's gone on with OJA and Odyssey. That's all beyond my level. But Sheriff, let me just make sure I'm understanding this. You're saying prior to the execution of the warrant, and let's assume it's a Sedgwick County warrant, that you want your office to obviously have access to it, but you also want every other law enforcement agency in the state to have access to it because maybe they find the defendant in their county. Is that what you're saying here?
No, we can't make this just for the Sedgwick County
Oh,
Sheriff's.
no, I don't mean that. No, I'm
Yeah.
talking about why would we give other jurisdictions electronic access to your warrants that come out of Sedgwick County? Why does the Lane County Sheriff need it, or the Shawnee County Sheriff? Why wouldn't we just restrict it to the agency that was involved in obtaining the warrant?
Well, I think that's twofold, Representative. First off, a lot of warrants come to us out of the Wichita Police Department. They're not even our warrants, and we have to have access to those. The second piece of that is it's more of a question for OJA. Why did they set up the system this way? Because right now, with sync cases and those type of things, it's a statewide system. So every DA can get access to any sync case that takes place. That's currently the way it works anyway.
Well, I can't answer your question, Sheriff. They're not on my list of witnesses, so I don't know the answer to that question.
Yeah, and I'm not being facetious here. I'm just saying that you're now understanding our frustration with this whole system.
Thank you. Okay, committee, any other questions for Sheriff Easter? I do have a question. Before we had the Odyssey system, how did you get the information prior to executing the warrants?
So again, I can speak for Sedgwick County, but most of the counties had their own records management system with the courts, the DA's office, that also law enforcement was attached to. So we had the ability within that system to be able to look up all this information once it occurred. And so when OJA made the decision that everybody in the state has to be on one system, that's when they shut down a lot of information that was before at our fingertips. Like I said, the DA's office, they file sync cases, but they didn't even have access to their own affidavits when we began this process. And so after 3 years of working with OJA, for them to understand how it really works in our jurisdictions, some of those things have been corrected. This is one that still has not been corrected.
Okay. Okay, thank you. All right, committee, do you have any other questions for our proponent? Okay, seeing no questions, no further questions. Thank you, Sheriff. We appreciate you being with us.
Thank you.
Committee, we have written only neutral testimony, and we don't have any opponents. Is there anybody, neutral proponent or opponent, that would like to say anything? Okay. All right. With that, seeing none, I will close the hearing on Senate Bill 186. And go ahead and open the hearing on Senate Bill 204. And again, ask our reviser, Jason Thompson, to give us a brief.
All right. Thank you again, Madam Chair. As you mentioned, Jason Thompson, Revisor's Office. So Senate Bill 204 comes to you as amended by Senate Committee of the Whole and also amended by the Senate Committee on Judiciary. It did pass the Senate 40-0. The bill requires case and warrant information to be sealed in criminal and juvenile offender cases. You'll see that the statute amended is KSA 60-2617, which is up in the civil procedure area of our code, but is applicable to not just civil cases. The new subsection A that's added there beginning in line 8 would provide that upon the filing of a criminal or juvenile offender case in which an arrest warrant is being sought, the case shall be sealed until such warrant has been executed or the request for such warrant is denied. Further, all subpoenas issued in those cases shall be sealed and shall only be unsealed if the court makes a finding that unsealing the subpoena is in the interest of justice. The definition of seal that is added in the bill would mean that no information related to a case, warrant, or subpoena, including its existence, shall be made available to the public. The new subsection would be applied retroactively to any case or warrant information or subpoenas that are currently pending. So it would go back to anything that's pending now. The bill as amended also provides a new subsection. It's technically a new paragraph within the subsection, and you'll see that in the bold italic language beginning in line 20 and then on to lines 25. This means that the new subsection A does not apply to a couple of things. First, it does not prohibit disclosure of warrant information, subpoenas, or other case information to law enforcement for the purpose of executing the warrant or serving the subpoena, kind of related to the issue we were just talking about. And second, it does not apply to a warrant issued pursuant to KSA 22-2807. And you're getting familiar with that statute because it deals with appearance bonds. So that's the one that the bonds folks would like, so that they can see the warrants that are issued and not have them be sealed. The bill, if adopted, would take effect on July 1st, and I'll be happy to answer questions if I can.
Okay, thank you, Jason. I do have a quick question. In the bill on line 11, at the end, it says nothing in this, and does that take us then down to line 20? Or how would that,
Good question, Madam Chair. So the bill as proposed, right? So this is a current section of law. So the language proposed in the original bill began there in line 8 and went through line 13.
I see.
And then in the Senate committee, they removed that end of that paragraph and instead created a new provision down in line 20.
Okay.
So, and they did that to kind of say nothing shall prohibit these, the Senate committee only did the first one. Nothing in this section shall prohibit disclosure of warrant information. So you can see kind of what was added by the committee of the whole was the little bracket with the colon in line 20, right? And the A in line 21, and then the semi-or in 23, and lines 24 and 25, and then the end bracket. That was added in the Senate committee of the whole. So the Senate committee said, well, instead of just sticking up this nothing in this section up in paragraph 1, they did a different version of that in paragraph 4. And then the committee of the whole added the provision that's essentially the bond provision that I was just talking about.
Okay, great.
So.
Thank you for that explanation. Committee, what other questions do you have? Representative Carmichael.
Thank you, Mr. Thompson. Returning to where we were just at about apply to a warrant issued pursuant to 22-2807 and amendments thereto. If Mr. Rolfe's company, who was here testifying a few days ago, was on the bond, I can understand that they'd want to get access to it. But what about one of his competitors or other bonding companies? Does every bonding company in the state have access to this, or only the bonds person who is on the defendant's bond?
So I'll have to go, Madam Chair, I'll have to go look at 22-2807 to refresh my recollection, but I believe you're limited to only the warrants related to the bonds you issued in that statute.
Okay.
So what this one is saying is that you're not automatically going to seal the warrant issued pursuant to that statute. But then your access to that warrant, I think, is still limited by that statute. That's my understanding. I know they've submitted testimony. I don't know if they're going to do that verbally or just written, but and maybe the conferees can kind of talk about that too. What does that access mean? But I'm pretty sure from reading 2807 recently that your access is still limited to the bonds that you are on. You can't.
And I see it's a long statute.
Yep, so maybe when you get back to your seat, if you get an answer to that, you can let us know. Do you have any other questions, committee? Okay, oh, sorry, Representative Barth.
Thank you, Madam Chair. Okay, line 11, it appears that they forgot to strike something, unless I'm reading this wrong, where at the end of that sentence, it says nothing in this, and then they already struck the rest of it, but there's nothing to complete those 3 words. Is that right?
It's not. Okay, that's interesting because must have been some version where nothing in this was not struck, but in this version, it was.
Yeah.
Yep. Mm-hmm.
Okay. All right, so the version we have is not, I need to go online.
That was my question too, but
Okay.
okay.
And online, it's correct, just so everybody's aware. Thank you.
Okay, So the proofreaders found something apparently.
Yeah.
Okay,
Sorry, Madam Chair. Apparently there
that's
was a printing error or some error along the way, but the version as amended by the Senate Committee of the Whole that you can get from the document room, and I think is the one online, the last three words in line 11 should be gone.
Okay.
And then everything in line 12 and 13 is gone
yeah.
as well.
Thank you for asking that question, because, yep. Yeah. Okay, any other questions, committee? Yeah. Okay, thank you, Jason, appreciate it. Okay, we have two proponents for that bill, both on WebEx. We'll go ahead and call Kansas County and District Attorneys Association, our DA from Sedgwick County, Mark Bennett. Can you hear us? Are you there? He's not on there yet. Okay, but we do have Sheriff Jeff Easter still with us. Okay, Sheriff Easter, would you go ahead and give us your proponent testimony for Senate Bill 204? And go
Yes,
ahead and introduce yourself again. Yeah.
yes, I'm Jeff Easter with the Sedgwick County Sheriff's Office, but I'm representing KPOA and the Kansas Chiefs of Police Association as well on this particular bill. And thank you for your time again, committee members. We all believe that juvenile records should be sealed without a doubt. And this is particularly true of arrest warrants and associated affidavit. The sealing of arrest warrants and related affidavits is not only necessary due to the juvenile nature of the case, but also critical for officer safety, that this information not be made public prior to service of the warrant. We also note that in KSA 215906, makes it a crime to disclose arrest or search warrant information prior to the service of the warrant. Disclosure of the affidavit also discloses a warrant is being sought. And so we are proponents of this bill for those reasons. The amendment that was made, again, going back to what I just testified to, that's why we're asking that in this bill, we also have access to that information so that we can do our job properly. And with that, I will stand for any questions.
Okay, thank you for that. I think we'll hold questions if you can just hang on for a little bit longer.
Absolutely.
Okay, that would be great. I'm not sure, so we still don't have Mark Bennett on. Okay. Well, I think there could have been maybe possibly did you think you sent for RDA from Johnson County? Why don't you go ahead and come up? I don't think we have your written testimony. Is that true? It's not on the S drive. Okay. Don't think we have your written testimony, but please go ahead and then you might just resend it or make sure we get it. And then, okay. Yep.
I apologize for that. I'm Steve Howe, Johnson County DA. I don't know what happened. As you know, it's the session's moving fast, and there might have been a clerical error on my part, so I apologize. I am happy to be here to talk about Senate Bill 204 because it has a real dramatic impact on the lives of victims of violence, law enforcement, and our general community. So it's a public safety issue. I would say doesn't matter what side of the aisle you're on, that this is something that everyone can support. And I want to give you a little backdrop behind Senate Bill 204. As you've already heard about, the Odyssey Court Management System started to go into play across the state. And as it started to go online, prosecutors across the state, including Mark Bennett, who you just referenced, that was potentially on WebEx, and myself, and a couple of other prosecutors met with OJA and the Supreme Court about some concerns we had regarding public safety. We indicated to them that based on the Odyssey case management system, warrants that are filed on criminal cases would be viewable by the general public. And we mentioned to them that that was a public safety issue, and in fact, we felt that it was inconsistent with KSA 215906, which is the criminal statute that says you're not supposed to disclose the existence of a warrant. The court took the position that the words "warrant issued" would be deleted, but rest of the information would still be contained in public view. And what I always say is you don't have to be a rocket scientist to figure out if I see that I have criminal charges and I haven't been arrested, then therefore I probably know that I have an arrest warrant for my arrest. However, our our recourse on that is of course limited, because if the appellate courts tell us that this is their interpretation of the law, then we have no recourse, because they're going to be the body that's actually going to hear our appeal. So we took another course of action. We tried to recommend that they make an administrative change into their Supreme Court rules. They were not willing to do so, and they indicated that this has to be a legislative fix. So that's why I'm here. And so I come before you, and there's two components of this bill that are extremely important for public safety. The first one, the arrest warrant that I just spoke of. The arrest warrant, so when we issue an arrest warrant for somebody, all law enforcement has the ability to see that on NCIC and can execute on warrants. The problem is, if a criminal defendant knows they have a warrant for their arrest, that is a recipe for disaster. I can't tell you the number of fatality accidents that happen in my county alone, where individuals know they have warrants for their arrest. They run from police, and the police anymore just back off almost immediately if you get in a high-speed chase, and they still careen into innocent individuals, maiming and killing a lot of folks. And some of this can be very small misdemeanor offenses that cause these people to run from authorities. We were told that the only way that we could seal those warrants is if we are able to give case-specific information as to why this needs to be sealed for public safety reasons. And I will tell you, from a county that files anywhere from 1,500 to 1,700 domestic violence cases, I can't pick out which case that a criminal defendant may kill their significant other. I think some of us remember the movie Minority Report. Unfortunately, we don't live in that world where we can tell what future behavior is going to be. And so many times, since this system has gone online in Johnson County, which is in November of 24, just last year, already we've had domestic violence victims deeply concerned about this being public because it puts them at risk. And so we're asking that warrant information be sealed until the warrant is executed. Once the warrant is executed and the person's placed under arrest, it then becomes public view for everyone to have access to. To us, that makes great public safety. It makes sense from a public safety standpoint for the victims and for law enforcement, and also for the protection of the general public. The second component of this bill deals with the subpoenas that we issue in criminal cases. It happens thousands of times a week by my office. And so we issue a subpoena, and if I issue a subpoena for Representative Curtis, I'm going to have her name and her address on it. And so that is now public view. And so many of our domestic violence victims have moved from their perpetrators and are trying to escape being known where they live. And if you look at the testimony of Heidi Wooten from Safe Home, she gives you a case example. In the last 3 months already, we've had multiple domestic violence victims where their information is disclosed. Again, and the only way that we could seal it is if we give case-specific information about why we need to seal it. Again, I can't do that in each and every case because I can't predict human behavior, but it puts victims at risk. The other component of it is if I am a domestic violence victim and I have injuries, the standard practice in my office and prosecutors across the state is to ask for medical records so we can determine the scope of the injuries that you receive, because it could impact the level of charge that we file. Well, when we send the subpoena and we ask for your medical records, we either have to list your date of birth or your Social Security number. Under Odyssey, subpoenas are public viewed. So if I put issue a subpoena, your date of birth or your Social Security number and where you went to get your injuries treated is all in public view. Think of it in another way. Let's say you're a victim of fraud and I want your bank account number. I've got to list your bank account number to Bank of America so they know whose bank account records to get to me. So I broadcast to the world your bank account number, maybe your Social Security number. Again, subpoenas are considered public viewed. under Odyssey, under the old systems that the prosecutors and the court systems used, they were not open to the public. So the second component of this request is to seal the subpoenas from public view to protect the personal identification information. This body has found that personal identification information should not be disclosed in things like the Open Records Act. You make that as an exception, that that kind of information is not disclosed, and throughout our state statutes. The Supreme Court even has information that personal identification information should not be disclosed. So everybody recognizes that this day and age in particular, that releasing that information has real dire consequences on people. And so we're asking that you pass this bill to allow us to seal those subpoenas so that we don't have a list of names of sexual assault victims or domestic violence victims, of minor kids who have been victimized that we have to subpoena. And so by doing this, we protect those individuals who have already been traumatized and are involved in the criminal justice system. That is why, if you look at the list of agencies that are in favor of this, it is a lot of our social agencies that support victims of violence, like Safe Home that I just mentioned, the Wichita Family Crisis Center, Sunflower House, our Child Assessment Center, MOXA, our Sexual Assault Support Agency. And so the Sheriff's Association and police agencies are also very supportive of this bill. It's truly not a political bill. It's a public safety issue that we can all get around. I will tell you that the prosecutors are all very supportive of this, whether you're Republican or Democrat. You've heard that Mark Bennett has submitted testimony. I know my neighbor to the north, Mark Dupree, wanted me to indicate that he's also very supportive of this as well. This is something that truly is a public safety issue. We would ask that you pass this. Now, as we went through the Senate, we determined that there might be some language that we need to include, and I will get you a copy of my testimony, and that is, when we figured out that we said subpoenas, we realized that the return of service documents have the same information on it. Those are also public information. And so I'm going to ask for a friendly amendment. Basically, it would say all subpoenas and then add and their return of service document. And then that way we cover both sides of it, because it's my understanding that that would be considered a different document. And if we don't include that, then the same information would be disclosed. And so that's the purpose of it. I appreciate your time, and when appropriate, I'd be more than happy to answer any questions. Thank you, Madam Chair.
Okay, yep. Thank you so much for your testimony. And we do have DA Mark Bennett on WebEx now, so we'll hold questions until all three of you have gone. Okay, Mr. Bennett, are you there?
I am, thank you.
Yep, okay, there we can see you also. So, yep, thank you for joining and welcome to committee. Go ahead.
Thank you very much. I'll be brief. I heard Steve's testimony, so I won't just reiterate the same thing, but I will say that for the first 25 years or so that I was in practice, when we filed complaints with a warrant, that was never a public record. That was consistent with existing state law, 2617, 2617, and other statutes that are listed in my written testimony. But with Odyssey, things change, and I think it was just really a function of the law catching up with the technology, and so this is what this bill is intended to do. And then, as Steve said, there's the friendly amendment that I believe it's, I think I had it as page 1, lines 14 through 17, but at any rate, it reads all subpoenas, currently reads all subpoenas issued in a criminal case or a case pursuant. It would now read all subpoenas and their return of service document issued in a criminal case. So again, it sounds like Steve's got a document there he's going to submit, but I want to point out one other thing though, and Steve may have said this and I missed it, but just so we're clear, this is not going to impact in any way the information provided to a defendant or his attorney. They'll have this information. Counsel for both sides will have access to it. It's just simply the outward-facing public documents that would contain either the fact that a warrant's pending and for officer safety reasons, obviously you don't want people to know that I've got an active warrant so I can get ready for the cops. And then two, for all the reasons you said with respect to subpoenas and all the information that's sometimes contained in those subpoenas, we don't want that outward facing for the world to see people's social security numbers, things like that. So it wouldn't in any way inhibit the defense ability to see who we're subpoenaing and what we're getting and the discovery process. None of that would be impacted. This is simply the outward facing information so the public doesn't have it. So I'll leave it at that. Again, stand for any questions, but just wanted to reiterate the fact that this really is a just a kind of a cleanup measure to try to make sure that the technology we've been given through this Odyssey system, that we close any public safety loopholes that had been not been closed before. So that's it. Thank you very much for your time and attention.
Okay, thank you. We'll take questions from the committee now. Committee, what questions do you have? Anybody? Representative Carmichael, and just let us know who you'd like to answer the question.
First, I was going to say, I just didn't want to step in line in front of somebody else. If there's somebody else who wants to step
Please,
off the
come on.
precipice, yeah, please,
Okay.
please, make a fool out of yourself before I make a fool out of me. But I don't care whichever one of our district attorneys wants to help me with a few questions. I'll try to keep it short. I'd like you to look at the language that the Senate added at lines 24 and 25, sub B, apply to a warrant issued pursuant to KSA 2807, amendments there too. And of course, my computer's gone dead, but as Mr. Thompson, I think, said, that's bond forfeitures. It looks like failure to appear on bond, skip and bail. And it looks to me like the Senate Amendment 24 and 25 just leaves those types of warrants unsealed. It doesn't say release the bonds first, it just say they're not sealed. And maybe that's okay because defendant knows he's on the lam, he didn't show up for court.
That is correct.
But I want to make sure that that's your intent, and then I can put that issue to bed in my mind.
That is correct.
Good, I'll rest easy. Now, if I might, Madam Chair, I need to ask about the subpoenas. The objective here, is it to keep the identity of the witness, the name of the witness sealed, or is it to keep addresses, bank account numbers, dates of birth, social security numbers?
All of the above.
The name as well?
Yes, in some instances, I will tell you, and in some of our filings, we use initials. So like anytime you have a victim of a sexual assault, or if you have a minor, that we use initials on that, so their names are never listed on the court documents, including the affidavit and the complaint.
And I assume that also applies to, and I don't know how you do it now, it's been 45 years since I did any of this, but that also implies, I assume, to endorsement of witnesses?
Yes.
Typically, the state has to list their witnesses at various stages of proceeding. That applies to that as well. So are we going to then wipe those names off of other pleadings that you may file that are witness lists, or sometimes they're endorsed on the complaint, as I recall, their complaint information? Help me with that.
Yeah, so in certain types of cases, we do use initials throughout everything, including our pleadings. And so like if you have a sexual assault victim, the initials would be used throughout. And the reason why we're able to do that is Supreme Court rule says that we can do it. And additionally, the criminal defense attorney has access to all the discovery and the real names of the individuals involved. And so the judge and the criminal defense attorney know the actual names, but not the general public. The same thing with minors using their initials instead of naming those individuals in public documents.
Final thing, Madam Chair, I just can't see in at least the statute in front of me where it is that defense counsel is granted access to the actual subpoena to see what you subpoenaed and from whom. Is that somewhere in some other rule?
No, based on Odyssey's system, there's an enhanced access given to the judges and the attorneys of record in those cases. So this would not prohibit the attorneys from seeing access to those things, only the general public.
Things have changed because I remember we kept that stuff in a file drawer and there were like 10 keys floating around the office.
Right.
Thank you.
Representative Curtis.
Thank you, Madam Chair. So does this pretty much codify what is done today in practice? Does this change how you actually operate or operated before Odyssey?
That is correct.
Okay. And it seems like, just a comment, this bill and the previous bill that we heard, it seems like we have some unintended consequences with adopting Odyssey, our court management system, which was a good move for us to do to, bring all of that together, managing throughout the state. But yes, seems like there are some unintended consequences we're going to have to deal with. So thank you.
Okay, committee, any other questions? Go ahead.
Mr. Howe, help me understand, though, where is the authorization in this statutory scheme for the clerk to release this confidential information to the defendant through this different level of Odyssey?
Well, it's based on the Odyssey system. They have permissions of who has access.
Right, I understand how they could set it up, but where's the statutory authorization for the delivery of that information through enhanced Odyssey after we seal it in this bill?
So the Odyssey system has its rules about who has access, but also in addition to that, as part of the discovery process, when you're a practicing lawyer and entering your appearance, you have enhanced access to the documents pursuant to a variety of statutes that I'm aware of. I couldn't name them right off the top of my head, but the attorneys have that enhanced access, full discovery as provided by the prosecutors. And so this doesn't preclude the defense attorney from having the necessary access to defend their clients.
I understand that to be your intent. I'm not sure the black letter of this statute matches that intent. Thank you.
Okay, before you go, Jason, there was that one question I think that Representative Carmichael asked you when you were standing up there. Do you have an answer to that? And will you remind us what the question was?
Madam Chair, I think the representative was asking a similar question to the district attorney there about KSA 22-2807 and the forfeiture of appearance bond and then the warrant that's issued for your arrest. So the confusion is potentially that right now that statute doesn't actually talk about the bail agent getting the warrant. You remember you have a bill that makes clear that they can have that upon request. And they're having some issues getting that apparently, sometimes from the court or from law enforcement. But to the representative's point and the district attorney's point, this would make clear, the bill would make clear that those are just not sealed. And so if you are allowed access to that warrant, such as in the bill that you've got proposed, or you're somehow otherwise granted access to that warrant, it's not sealed. So it kind of works together, even if you amend it, I think. So.
Okay, thank you so much for that. My last question, you mentioned the open records. And so it just made me think, can you just address that anything that is open to the public, I mean, so you're trying to seal things, but if they're not, are they open records accessible, or do we have exceptions to the court records? And maybe that's a question for the revisor.
There are exceptions under the Open Records Act for some of these things, such as minor individuals, date of birth, social security numbers. Those are all exceptions to the Open Records Act. And there's a pretty long list of personal identification information that is precluded.
Okay, thank you. All right, any other questions, committee? Okay, thank you so much. Thank you.
Madam Chair, if you want, I've got a copy I could give to the reviser since you somehow didn't get it.
And do you have that also electronically?
Yes, and you resubmitted it.
Okay, perfect.
Yeah.
That would be great. Thank you. Okay, committee, we have written neutral testimony from Michelle McCormick from the Kansas Coalition Against Sexual and Domestic Violence, and also from Shane Roth, the Kansas Bail Agents Association. And having no other opponent testimony, I will go ahead and close the hearing on Senate Bill 204. Thank you to those two that are on WebEx. We appreciate you being with us. And also thank you, DA Howe. Yep. Okay, thank you. Okay, we will now go ahead and open the hearing on Senate Bill 54. This is something, if you have been in this committee before, you are familiar with this topic. But Jason, go ahead and explain it to us, please.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again, and yes, this is a familiar topic. Yeah, a few late nights thinking about this language, let me tell you. Especially in conference committee time. So anyway, just to get it out of the way, I saw in the testimony it's mentioned, but last year this was a 2024 House bill. It was 2510. If you wanted to look up your voting record, it passed out of this committee and it passed the House 83-39. So if you were here, you may have voted for it. And the substitute bill is not really that similar to it, although it is the same topic. So I'll stick to just describing the substitute bill rather than getting into any sort of comparison. The substitute bill comes to you from the Committee on Judiciary in the Senate. It did pass the Senate 39-1 on final action. It limits discovery and disclosure of third-party litigation funding agreements. And it also requires some reporting of those agreements to the court and eventually from the court to the Judicial Council for study. The bill is amending KSA 60-226, which to the lawyers in the room is very familiar to you, and the rules of civil procedure. This is the discovery statute. So amending an existing discovery statute to add some provisions related to third-party litigation funding agreements. I gave you the definition there in the bill brief. It's also provided in the bill. So if you want to look at the actual text of the definition, which I always recommend, you'll find that definition on page 9. Beginning in line 8. I've also given it to you in the bill brief, and that's what I'll read. These agreements mean any agreement under which any person other than a party, an attorney representing the party, such attorney's firm, or a member of the family or household of a party has agreed to pay expenses directly related to prosecuting the legal claim and has a contractual right to receive compensation that is contingent in any respect on the outcome of the claim. So you have an interest in the litigation, and that is what your fee is contingent on. That's the very short summary there. However, there are exceptions. It does not include an agreement that does not afford the non-party agreeing to pay those expenses any profit from the legal claim beyond just mere repayment. Plus a reasonable interest rate, which is defined in the bill specifically as an interest rate not greater than 11.1% of the principal. So if you're asking for a simple repayment with an interest rate lower than 11.1%, you don't have a third-party litigation funding agreement. But if you have, expenses paid and contingent on outcome of the claim, you do. So there's kind of the universe of agreements we're talking about here. The bill provides that a party shall provide the court for in-camera review any third-party litigation funding agreement within 30 days after the action is commenced or 30 days after execution of one of the agreements, whichever is later. So if you have one of these agreements, you're required to notify the court, and the court will review it in camera. Sorry, Latin lawyer stuff. The court will look at it on its own, right? Just the court. That's what that means. It will not be reviewed by anyone other than the court. Except as otherwise stipulated by the parties. If you've entered into one of these agreements, the party has to deliver to all of the other parties within 30 days after the legal action commences or after the funding agreement is executed, a sworn statement disclosing 6 items. And I won't read those 6 items. I've laid them out in the bill brief. They're also laid out in the bill. It's essentially talking about the identifying the contracting parties, whether it gives them any control or approval rights regarding the litigation, et cetera. Then the bill provides that information concerning those agreements is not necessarily admissible in evidence at trial just because it's been disclosed, and it doesn't require a nonprofit corporation to disclose their members or donors. And other than the in-camera review that I kind of talked about by the court, nothing is construed to modify sort of the other rules of evidence related to these agreements or discovery requirements related to these agreements. So there's some kind of exceptions to things that might occur without those exceptions. There's also a reporting requirement, and I won't dwell on this too much because I've seen and heard from the testimony that some of this may be coming out, but there is a reporting requirement where the court is going to turn over information about these agreements to the Judicial Council, and the Judicial Council would study these agreements and report to the Legislature and the Chief Justice of the Supreme Court and the Attorney General their findings on sort of how these are being used in Kansas. And that's the rest of the bill brief, I think. Happy to answer questions if I can.
Thank you, Jason. Committee, what questions do you have for Jason? Representative Osman.
Thank you, Madam Chair. I actually don't have a question for the reviser, but just a question on the printed daily agenda has 2 opponents, written only listed, but online it doesn't have them, and the S drive doesn't have their testimony.
So it's on the website, but not the S drive.
There are also copies out on the table. I just went and got them.
Oh, thank you.
That's fine. Okay.
Yeah, it's hard to prepare sometimes. I appreciate it.
Yes, our committee assistant has a lot of paperwork and things going on, so. Okay, Representative Lewis.
Thank you, Madam Chair. I just wanted, and I carried the bill last year, but this is a little different. So I just wanted to be clear. As I read the bill, it doesn't in any way prohibit these agreements. The idea is that information about them will be given to the court and to the opposing side, so that if there's some sort of impropriety with respect to them, then steps could be taken to disallow. Is that the rationale behind the bill, as you understand it?
Madam Chair and Representative, I will defer to you to explain the rationale. I think you have a pretty good idea of what's going on behind the bill. I will agree that there's nothing in the bill that prohibits these agreements. It just says if you have one that meets the requirements, you have to disclose it to the court and to the other parties. And then it might be further disclosed to the Judicial Council to be studied, but they are allowed. You are allowed to have them. I mean, within all other constraints of the law, legal ethics, right, sometimes come into play. You know, your ability to represent your client. There are a number of issues I think that were raised about the propriety of the agreements, which could come into play once they're disclosed, but the agreements themselves are not prohibited by the bill.
Thank you.
Okay, any other questions for the reviser? Okay, thank you, Jason. I will go ahead and call the proponents. First, Eric Stafford from the Kansas Chamber. Welcome back to our committee. Did he try to trip you?
He did.
Mm-hmm.
I think we have a bunch of lawyers in here who saw that. Thank you, Madam Chair, members of the committee. My name is Eric Stafford, Vice President of Government Affairs for the Kansas Chamber. We do appreciate the opportunity to speak in support of Senate Bill 54 today. I've got a lot to cover. I'm going to try and get there quickly. First, I want to start by saying that ultimately Senate Bill 54 was introduced as House Bill 2510 that passed last year, as Mr. Thompson mentioned. That bill is significantly different, and the reason it's different is because I'm pleased to report that the opponents from last year's bill and proponents of the bill have been able to reach a compromise, which is why it passed the Senate 39-1. So with that said, Mr. Federico said he'd like to sing a song about harmony and compromise. So do you want to go ahead and come up
Yeah.
and do that now or at the end? Just keep going? Okay. Yeah, so we do have a compromise here before you today in Senate Bill 54. This is an issue that's been around the legislature for 4 years. And disclosure of these third-party agreements is ultimately our goal, and I'm pleased that we were able to reach agreement there on the bill that's before you today. For the new committee members, I'll get into what third-party litigation funding agreements are. And again, to Representative Lewis's question, we are not trying to ban them. We believe out of fairness for the judiciary, disclosure is good. If there is somebody that has a financial interest in the outcome of the case, which in these current times, there are investment companies, hedge funds that invest in litigation. They have teams of attorneys that review lawsuits being filed all across the country. Attorneys and law firms that are a member of our organization, they get these phone calls, they see them. Opponents actually of the bill last year, I believe on behalf of KTLA, spoke saying, yeah, we get called by these folks, but we don't take them. So they are out there, and they do have an interest in cases in Kansas. And so we brought House Bill 2510 last year to the House because the Senate had heard it. It was a similar language to what had been around the previous 2 years. And then last year's bill had very strong neutral testimony from the Attorney General's office out of concern to public interest, nonprofit type of litigation. That turned into several weeks of negotiations and then a much longer bill than what we had before. That was then passed through the House, became Senate Bill 54 this year. And our bill is much shorter than that version now, but we were able to negotiate this right before turnaround. I mean, you'll see in my written comments, there's a couple amendments that we're going to request. One of them is grammatical. There's an of that should be an or, but we literally reached agreement at 8:30, 9 o'clock in the morning before before Senate Judiciary worked this bill on the last day of committees before turnaround. So thankfully, we appreciate the opponents willing to sit down and work with us on language, and I think both sides are comfortable where we're at with the bill today. I will get into the amendments. The Judicial Council report that Mr. Thompson talked about, both sides are in agreement. That was intended to be studied just to see where this is as an issue in the state. Both sides are comfortable taking that piece out since there is an agreement here today. If it's not going to be taken out by the committee, then the Judicial Council needs to have that language amended, and I have that language that could be provided. So I can give both copies to the chair and go from there, but that was not a request from us. I believe that was an Attorney General request on the study last year. So but both sides, Mr. Federico's clients and our interests, we're comfortable taking that reporting provision out. And then additionally, I mentioned the of to or, that's in B1, B2 on page 2, line 39, referenced in our written testimony as well. So really what we're after here is transparency out of fairness for the defense. If there is a third-party funder to a case, helps them make their decisions on how to proceed with litigation, whether settlements in their best interest or litigations in their best interest. But if they don't have that whole picture, they can't make that decision. So again, I just want to reiterate that we appreciate the opponents willing to sit down with us and hammer out some language. It was actually a call that was ended after 5 o'clock on Valentine's Day, so it was pretty painful. But we ultimately got a product worked out over the weekend through a lot of emails. So happy to answer any questions, Madam Chair, about this, but you guys are largely familiar with the issue and pleased to report that we took care of the concerns from our main opponents last year.
Yeah, thank you so much. So committee, we have listed Dan Murray and Rochelle Colombo as in person. They're not able to be here, so they will be written only. So Mr. Stafford is our only in-person proponent, so we'll go ahead and ask you questions. Sure. That's okay with you. My first question is, I seem to remember another piece put in that the Attorney General wanted that was sort of protection for nonprofits, disclosure of donors or something like that. Is that still in here, or what kind of happened with that piece since last year?
Yeah, good question, Madam Chair. There is still protection in there. And I'm scrolling through the bill here. Figures I can't find it while I'm looking for it.
Okay, page 3, line 12-ish.
Yes, yeah. Subsection B3B1 shall not be construed to require a nonprofit corporation or association to disclose its members or donors. That was actually a recommendation from Senator Titus on the Senate side to include in language that we negotiated through to make sure that he felt like that offered the same protections in a cleaner way.
Okay,
so
yeah,
that
because
is
it's a
still
little
in
bit
there.
different, but
Yeah, sorry it took me a while to find that.
no, it's okay. Once I asked, I found it, but yeah, thank you. But it's good to point out to the whole committee too. All right, committee, what other questions do you have for Mr. Stafford? Representative Vaughn.
Thank you, Madam Chair. Thank you, Mr. Stafford. I Just wanted to clarify, if you don't mind sharing who is part of the proposed compromise. We still have some opponents today, so just wondered if their concerns were taken into account or what outstanding concerns might be.
Yeah, absolutely. Good question, Madam Chair. That was, Representative, it was ourselves and folks that we've been working with, attorneys on our side, and then International Litigation Funding Association, ILFA, and their attorneys is who participated in that discussion. I don't believe KTLA was involved in those or the bar. I think it was just our two groups. Yep.
Okay, any other questions, committee? Representative Osman and then Lewis.
Thank you, Madam Chair. So I might need to do a more thorough reading of the Senate Bill 54 before I make any determinations, and obviously we'll have that time before working the bill itself. But one of the primary objections last year was just the knowledge of a third-party litigant or third-party funder radically changes the negotiation tactics that happen on both sides. And so what is it that's being clarified under this revised Senate Bill 54 that would help to address that particular issue of knowledge being an inequitable solution to what's going on here?
Madam Chair and Representative, I'm going to take the liberty of trying to speak from opponent's perspective, and I think I might defer to John if I get this wrong. I think the concern largely was who has access to the agreement, right? And we weren't looking necessarily for the contract terms to be handed over, but at the same time, answering the provisions that are laid out that we negotiated through, I think it's 1 through 6, starting on page 2 into page 3, the limitations of what can be disclosed or what is turned over. So that's, I think it was still a little, even though we were successfully able to work out negotiations with the Attorney General's office last year, ILFA was still opposed to the bill. And in some cases, I think they viewed it as probably a little worse than what we started with because of some of the language that was used in it that opened up the opportunity for disclosure for some things that they view proprietary that they didn't want to have disclosed. And so I think this being limited in scope, I think it gets at the point of what the opponents had issue with and explicitly stating what can be disclosed. I'm hoping I'm answering your question there.
I believe so, yeah. I realize that you're probably not the best person to address this to. You were the proponent last year and you're now the proponent again this year. But as you're the only in-person proponent, you're who I'm talking to.
Lucky me.
Cool. All right, thank you.
Yep, you're welcome.
Representative Lewis.
Yeah, and this is more a comment, if I might, rather than a question. But so what I found informative last year as we thought about this. So on this bill, we're asking the plaintiff to disclose information about their funding source to the defendant. But the reverse happens all the time where you have a case of an insurance carrier involved. The plaintiff gets that information from the defense as to their insurance policy at the beginning of the litigation. So it's, both sides in those circumstances are getting information about how the other side is funding and what kind of resources they have to litigate. So in that sense, I think it's just balancing out that dynamic.
Okay, thank you. Any other questions, committee? Okay, I think that's it. Thank you so much.
Thank you, appreciate it.
Okay, so I do think when we work this bill, we can expect at least one, maybe other amendments. But also, committee, please make sure you look at the written proponents. They're all listed there, including Dan Murray and Rochelle Colombo, who were going to be here in person, plus Randy Stuckey, Craig Seepage, Samantha Woods, Marley Carpenter, Beth Smaller, Michael Stinson, and Philip Arnzen. And then we have written only opponent testimony from Callie Denton of the Kansas Trial Lawyers Association and Joe Molina from the Kansas Bar Association. Okay, any other comments or questions on Senate Bill 54? Okay, I will go ahead and close the hearing on Senate Bill 54. And committee, we are now going to work, sorry, I didn't write the number down, the laser pointer bill. That would be Senate Bill 156. And then we have a couple others, 3 others too, actually, so. 156, give you a minute to take a look at that. Okay, Jason, could you just give us a little bit of a reminder on what that's about? Hopefully y'all remember it was just yesterday that we heard it.
All right. Thank you, Madam Chair. Jason Thompson, Revisor's Office. Yeah, this is the bill you heard yesterday that creates the crime of unlawful use of a laser pointer and gives criminal penalties. One for pointing them at a law enforcement officer, that is a misdemeanor, and one for pointing them at an aircraft, which is a severity level 9 person felony.
Okay, committee, any discussion on this bill or amendments? Okay, I have an amendment. And I'll explain it as Jason is passing it out. It's changing the effective date. Sorry. I have to say it less apologetically. I was thinking someone else might bring it. This was my last. Okay, yep. Again, the purpose of this is because if we change the date, let's just be forthright here. We have other we had another criminal bill, which was the purchasing sexual relations. We passed it out of committee. So we have 2 criminal bills that we've had in House Judiciary. We can conference on those and we can put them in the same bill if we decide to do that in conference committee. And so it just kind of saves, it makes 1 bill instead of 2. I think it makes it easier as we're passing things. I think both of those bills are, well, we'll see how y'all feel about this one, but I think the other one we passed out unanimously. And so that's being completely forthright, since that's what we're talking about today. That would be the reason to do this, so everyone understands. I don't think anyone explained that to me when I was a freshman. Okay, so I move that we amend Senate Bill 156, and I need a second on that. Representative Bohai seconds. Any discussion on the amendment? Please, Representative Carmichael. Yeah.
Yes, I'll make my impassioned speech. The criminal statutes are supposed to start on July 1. That way the public has notice of when something is against the law. So it's not a good idea to pass legislation based on an effective date in a statute. But I do hope members understand that there are 2 ways that I know of to manufacture shells, and there may be some others. One of which is to just introduce a bunch of duplicative litigation, same bill from the House, same bill from the Senate, send it to conference, and then they have all those extra bills to do nefarious things with. This is not that. This is instead amending a bill and sending it back to the Senate, realizing that they both have to do with criminal law. They're going to end up in the same bill, and then that leaves a shell. And then that shell can be used for other purposes. Now, I spent years on the leadership of this committee, and I know how important it is for Judiciary to have shells, and so this is a good bill. Amendment of a good bill.
Thank you. Thank you. Appreciate that. Any other comments? Okay, so committee, you've heard the motion to amend Senate Bill 156. All those in favor say aye. Opposed, no. Okay, so Senate Bill 156 is amended. Now, on the bill, do we have any other amendments? Do we have a motion? Representative Williams.
Thank you, Madam Chair. I move that we pass Senate Bill 156 as amended favorably for passage.
Representative Osmond seconds. Any discussion about this bill, committee? Okay, seeing none, would you like to close?
I close.
Thank you. So committee, you've heard the motion to pass Senate Bill 156 favorably as amended. All those in favor say aye. Opposed, no. The ayes have it, and Representative Carmichael would like his aye vote recorded. Anyone else? Okay, so we have passed Senate Bill 156. I now would ask you to take a look at Senate Bill 157. Yeah, that's March 5th. Second one. Okay, committee, we'll let Jason give us a reminder what Senate Bill 157 is about.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. This is the bill about warrants for failure to appear. That statute we were just talking about a little bit earlier, KSA 22-2807, requiring, is this the one? Yeah, this is the one that requires the court to make copies of the warrant available to the compensated sureties. It also talks about them, the surety getting some money back if a person is deported, and it has the 95% remittance if they return someone to custody within 180 days after judgment is entered against the law.
Okay, committee, do you have any comments or do we have any amendments? Okay, we do have an amendment, so I'll. Yeah. Okay, so yeah, we do have an amendment from the association, and Jason, you can go ahead and pass that out. Thank you. Jason, would you go ahead and explain the amendment to us, please?
Sure. Thank you again, Madam Chair. So as titled, this is the one that was discussed in testimony from the Kansas Bail Agents Association. The main changes are there in lines 15 through 17 to maybe add a little bit more clarity that what's supposed to be done within 14 days of issuance of the warrant is that the sheriff enters that in the NCIC database. And then upon request, the court will make a copy available to the surety. So there's no deadline for the request or the court. The deadline is for the sheriff. So a little bit of a restructuring, but some clarification that the proponents suggested was necessary. The change in the bottom of, on the bottom of page 1 is to remove the deportation language. So that's what those strikes are. And to return the word incarceration, since we're just kind of going back to current law. So that would go back to the way it is. If you can prove the defendant was incarcerated somewhere, then you can have the forfeiture set aside. That's what that does. And that's because they've replicated that language about deportation in a different way on page 2. So we'll get to that in just a second. Actually, I'll talk about it now. That's the big box on page 2 that's inserted in line 8. So this was the language they talked about where if the defendant was not held on an immigration detainer when the bond was posted and the surety can prove the defendant has now been deported prior to judgment of default, signed by the surety under penalty of perjury, setting forth the facts substantiating the deportation, they can get the forfeiture set aside. So that's the deportation provision they would like instead of the one that was on page 1 earlier. The change right above that, it looks like, oh, it's related to the change, the very first change, just to make clearer that if you don't provide the warrant if the sheriff does not enter the warrant within 14 days, that's one violation sort of under the statute that can lead to a forfeiture being set aside. The other violation would be not providing it to the surety upon request if you're the court. So it sort of separates those two folks, just like that first change did. So that's a clarifying amendment related to the first one. And then the last change is the one the representative was mentioning kind of off mic with the percentages and the number of days that was discussed a lot at the committee. So after entry of judgment, the court may remit in whole or in part to the bondsperson. And there's now a new provision that they shall remit a portion of the appearance bond to the obligor if returned within the following number of days. And then those would be 90%, 90 days, 75% up to 180, and then 50% up to 270. I think those are the three big changes, right? The separating the sheriff's requirement from the court requirement, which is in two places, the deportation change that was talked about, and then the remitting a portion of the bond to the obligor based on the number of days before they return the person to custody. I think that's the three.
Okay, thank you. We'll discuss the amendment. I'll go ahead and move the amendment. Do I have a second? Representative Williams seconds. Okay, what questions do you have about the amendment? Representative Osman.
Thank you very much, Madam Chair. I mean, I think the amendment makes the bill better, but even still, like, they had proponent testimony that said, like in Wyandotte County, or take deportation out of the question altogether. They had, the proponents were saying, if you find the person within 30 days and turn them back in, you're going to get about 66% of your bond back. Anything longer than that, good luck. Do not even bother to ask the question of whether your bond comes back or not. It's gone. And here we're putting into statute that within 90 days, you get 90%. All the way up to 270 days, you get 50%. So we're putting into statute effectively overriding what courts are doing to an extreme amount. So I'll support the amendment, but I think that even just the baseline bill is a problem.
Okay, any other comments, committee, or questions about it? I will just mention that the amendment was a compromise reached between the Sedgwick County DA and who also testified that he was okay with the bill. I know it's interesting when you look at it from the bond perspective, but it's also interesting when you look at it from the criminal justice perspective too, that if you get someone returned, then that's a good thing. And so if there's incentive to keep looking for someone, I think that's why I think it's an important piece of the puzzle on how we do bonds and how we get people back in court. Okay, any other discussion on the amendment? Okay, seeing none, committee, you've heard the amendment to amend Senate Bill 157. All those in favor say aye. Opposed, no. Okay, we have amended Senate Bill 157. Committee, I'm also, oh, no, it's just an amendment. He doesn't do, yeah. Okay. Sometimes. Okay, yeah. Okay, committee, I also would like for you to look now at Senate Bill 244, which we heard on the same day. So that would be March 5th. And I'd like to put the contents of Senate Bill 244 into Senate Bill 157. We didn't do a balloon amendment because I think it's really unnecessary. You understand Those two both go together. But Jason, would you remind us a little bit about Senate Bill 244?
Sure, thank you, Madam Chair. So 244 is the bill concerning appearance bonds, again, different statute, 22-2809B. So this, if you added it, would go in as section 2, right, after 2807 that's already in the bill. This is the one that requires, builds off of the changes you made a few years ago where the compensated surety has to charge a portion of the appearance bond upfront and receive payment upfront. It prohibits financing agreements, basically, or loans for those amounts. That's the big thing. I think that's all it does. Prohibits the surety from making loans for certain portions of that appearance bond. I thought there was more, but I think that's it.
Okay, so I'll go ahead and make an amendment to put, or I'll move an amendment to put Senate Bill 244 in the contents of Senate Bill 244 into Senate Bill 157. Do you have a second on that? Representative Williams seconds. What questions or comments do you have about that? Representative Carmichael.
Madam Chair, I will oppose the amendment. I was actually prepared to vote for Senate Bill 157 as amended, which is one we just did about the percentages that you get back based on the number of days the defendant had skipped bail. But 244 is a completely different matter. This is a continuation of legislation that we passed last year that was poorly drafted, that the intent was to create a restraint of trade and to price fix the amount of bail bonds in Kansas, to require that they had to be in certain amounts, certain percentages, etc. I can't remember all of the details, but the concept was that there were some bail bonds companies that were truly selling discount bail bonds. And the mainline bail bond industry didn't like that because they liked their fixed rate of 10% or even in some cases 15%, and they didn't like the competition of people who were undercutting them at 5% or 7.5%. And we passed that bill over my objection. And so what the what the discount bond companies did was said, we'll go ahead and you can pay your premium and the minimum amount required. We'll loan you the money to do it with. Well, the mainline bond companies, they don't like that either because frankly, it accomplishes the same purpose. So I oppose 244. I support 157 as amended. So I'm voting against the amendment on 244, and then we'll cross the bridge later on 157, depending on the outcome of the amendment. Thank you.
Committee, any other questions that you have on the amendment to put 244 into 157? Okay, so hearing no other questions, I close and committee, you've heard the motion. Just 1 second. To amend Senate Bill 244 into the we're amending Senate Bill 157 by putting the contents of Senate Bill 244 into that. All those in favor say aye. Opposed, no. I would say the chair is in doubt. So all those in favor of putting the contents of Senate Bill 244 into 157, please raise your right hand. Okay, I think that's 9. All those opposed, raise your right hand. 7, I think. So the amendment does pass.
Madam Chair, on that one, would you please record my negative vote on the amendment, please?
Absolutely.
Thank you.
Okay, committee, I also want you to take a look at Senate Bill 138. And we heard that on March the 4th. March 4th. Jason, will you tell us about Senate Bill 138?
Sure. Thank you again, Madam Chair. So 138 is the bill that requires search warrants to be issued only on the statement of facts sufficient to show probable cause made by a law enforcement officer. The current law says any person can state those facts, and this would say a law enforcement officer has to do that. Just technically speaking, since this is 22-2502, it would become section 1 of the amended bill. The others would be 2 and 3. So if you're curious how it would fit together.
And they all have to do with criminal procedure. This is a criminal procedure bundle. Okay, so committee, I'm asking for an amendment to place the contents of Senate Bill 138 into Senate Bill 157. And I'll go ahead and make that motion and ask for a second. Representative Williams seconds. What comments and questions do you have on this, committee? Representative Carmichael.
Thank you, Madam Chair. Senate Bill 138 is a good bill. But if it goes in with Senate Bill 157, then it becomes what's generically referred to as a bad bundle. One of the keys to successful bundling and creating shells, this is a little different. Earlier we were talking about creating shells in the conference committee. This is creating shells in this committee. But for that process to work successfully, you've got to bundle good bills that people support. Otherwise, members have to say, which do I want to do here? Do I want to support 244, which is a good bill, and 138, which is a good bill? But the price of doing that is I have to vote for 157, which is a bad bill. You don't put members in that circumstance, because then members earn postcards because they voted aye on 2 of the bills in the bundle and nay on 1 of the bills in the bundle, and then it's all called Senate Bill 157, and so you get blamed on the postcard for things you didn't really want to do. So this is a bad bundle. I don't support doing this. Thank you.
Do we have any other comments or questions? Committee, I will say, again, it's a criminal procedure bundle. If I thought any of them were bad bills, I clearly wouldn't be bundling together. So of course we have a difference of opinion. And sometimes it's surprising which ones I think people think are good or bad. So anyway, in this case, I think these were all good bills, and that's why we decided to put them together. We have a few House bills that I think some of us think are good bills. And so it was important to get a shell in our committee so that we could pass something out, possibly. We'll discuss that later, not today. So I think it's good to have a shell here in our committee also, just in case there's a House bill that we need to expedite. That's kind of the reason behind all of this, but also because our reviser has said that criminal procedure can all go together. These 3 all went together. I think they're 3 good bills, and I would ask you to go ahead and vote yes on the amendment to put House Bill or Senate Bill 138 into Senate Bill 157. Any other comments or questions? Nope. Okay. So I close on that. You've heard the amendment to amend Senate Bill 157 by placing the contents of Senate Bill 138 in it. All those in favor say aye. Opposed, no. The ayes appear to have it. The ayes do have it. And we will go ahead and make that bundle.
Madam Chair, would you please record my negative vote on the amendment?
Absolutely.
Thank you.
Got that. And Representative Curtis.
I just have a question. What is the bill number of this bundle?
The bill number is 157.
Okay. Thank you. And
The other 2 bills were put into 157, and they'll be section 1, 2, and 3.
Okay, and the 2 bills put in were 244 and 138. Gotcha. Okay, thank you.
Okay, any other questions, committee, for the day? Okay, so tomorrow we
we haven't
sorry, we have
passed
to pass
157, and
157.
I also have discussion on 157, not questions, but discussion.
Yes, of course. I'm so sorry. Yes, we have to vote on Senate Bill 157. Any other amendments? Discussion? Go ahead. Representative
It
Carmichael
appears
first
the
and then
ranking
Osborne.
member seeks recognition. Let me defer to him. He may
Okay,
cover it
Representative
much
Osborne.
more succinctly than I would.
No, actually, I'm happy to let Representative Carmichael talk. He is so eloquent. In fact, jumping off of what Representative Carmichael was saying earlier, and now that we have them all in a singular bill, beyond just the question of voting for good bills and bad bills and postcards, I would just say, as a note to legislative modernization, should they be listening to us, part of the problem is our inability and the public's inability to track any of these bills. Now that they've moved from one to the other, there is almost no record of it happening online. There is no record for us that know the process. It is really, really difficult to track and to figure out what's been going on. So if there was a better way online that not only the public, but the legislature can really track how this legislation is moving from one to the other and how it affects one to the other, it would make a lot of these bundling bills a lot more palatable. That is, outside the question of what is going on with 157, which I will defer to Representative Carmichael on.
Could I comment really quickly? I agree 100%. I think that makes so much sense. It's almost like is there such thing as a committee resolution? The Judiciary Committee has a resolution that we would like, to be able to track bills. So I don't think there is such a thing, but I would definitely approve it. And thank you for mentioning that because I agree 100%. Representative Carmichael.
Thank you, Madam Chair. It's nice to hear bipartisan consensus, but unfortunately, it's an issue over which we have no control whatsoever. I want to echo the remarks of the ranking member regarding the tracking of bills and what a problem this creates for the public at large, let alone members. But also, I do want to add that this idea of taking two bad bills and bundling them with one good bill places members in the same dilemma that I described when we were amending SB 244 into this legislation. So I'll have to be voting no on Senate Bill 157. I hope the bail bonds people understand that I actually intended to vote with them today.
Committee, any other questions or comments? Okay, seeing none, I'll go ahead and close. I will, we've moved and we've seconded to pass Senate Bill 157 favorably for passage as amended. All those in favor say aye. Opposed, no. The ayes appear to have it. I think the ayes do have it. So Senate Bill 157 is passed. And Representative Carmichael voted no on that one. Okay, any others? Okay, committee, thank you for your work. I appreciate it. Tomorrow we'll hear bills. If we work any bills, it might be Senate Bill 30 or Senate Bill 222, just so you know about that. Otherwise, I think that's it. And thank you for your work, and the meeting is adjourned.